Connecting compensation to supervision and risk. As we move forward from unlicensed activity, we now focus on one of the most enforced and misunderstood statutes in Arizona real estate, ARS, paragraph 32-2155. This statute directly controls who can be paid, how they are paid, and under what conditions compensation is lawful. When brokers fail to follow these rules, the result is often disciplinary action, even when the transaction itself was handled correctly. This section builds on prior concepts. Supervision, licensing, and compliance all come together through compensation. The core rule: only active licensees get paid. At its foundation, ARS, paragraph 32-2155 establishes a clear rule. A broker may only employ and compensate active licensees, and a licensee may only receive compensation from their employing broker. This means there is no flexibility, no side payments, no direct payments from clients, and no compensation to inactive or expired licensees. The law is designed to ensure that all compensation flows through the broker, reinforcing the broker's role as the responsible party in every transaction. Real-world example: the side payment. Mistake. Imagine a scenario where a buyer directly pays a salesperson a referral fee outside of escrow as a thank you. While this may seem harmless, it is a direct violation of ARS, paragraph 32-2155. Even if the transaction closes successfully, the act of receiving compensation outside of the broker structure creates liability. This ties directly back to Section 8. Improper compensation can be treated similarly to unlicensed activity. Payment through entities, professional corporations, and PLLCs. Arizona law allows licensees to receive compensation through a professional corporation or PLLC, but only if properly structured. The entity must be licensed, and the licensee must be an officer, shareholder, member, or manager of that entity. This is commonly used by experienced agents for tax planning, but it must be done correctly. If not, it can result in violations related to improper compensation handling. No license, no compensation, strict enforcement. ARS, paragraph 32-2155 also makes it unlawful to pay any person for performing licensed acts if they were not licensed at the time the service was rendered. This is critical. Even if a person later becomes licensed, they cannot be paid retroactively for work performed while unlicensed. This reinforces a consistent theme. Licensing status must be verified before any activity and before any compensation is issued. Good faith protection. Limited, but important. The statute does provide limited protection for parties who rely in good faith on a license. If an escrow company or broker verifies a license through an official certificate or identification card, they may be protected from penalties if the license later proves invalid. However, this does not remove the broker's responsibility for proper supervision. It simply provides a narrow defense when reasonable steps were taken. Mortgage activity, additional compliance layer. When a broker or salesperson earns compensation related to loan negotiation, additional requirements apply. They must be properly licensed under mortgage lending laws, disclose dual compensation, and ensure compliance with state and federal regulations. This is an area where many licensees unintentionally violate the law, earning multiple streams of compensation without proper disclosure. Leasing agents and property managers, limited exceptions. Arizona law allows brokers to employ residential leasing agents and property managers under specific exemptions found in ARS, paragraph 32-121. However, this does not remove the broker's duty to supervise. These individuals may perform certain activities without a license, but only within clearly defined limits. This ties directly back to earlier sections. Exemptions do not eliminate supervision responsibilities. Understanding exemptions, where licensing is not required. ARS, paragraph 32-121, outlines specific exemptions where a license is not required. These include property owners managing their own property, attorneys performing legal duties, court-appointed trustees, and certain property managers or leasing agents. It also includes administrative staff performing clerical duties and telemarketers gathering information as long as they do not engage in licensed activity. These exemptions are important, but dangerous if misunderstood. Crossing the line from administrative to licensed activity creates immediate liability. Real-world example: the administrative assistant trap. Consider an assistant who begins by scheduling showings, but gradually starts answering buyer questions about pricing and property details. At that moment, they have crossed into licensed activity. If they are compensated in any way tied to that activity, the violation expands under ARS, paragraph 32-2155. This example reinforces a key concept. Roles must be clearly defined and enforced through supervision and policy. Broker oversight, the final line of defense. Ultimately, compensation compliance always leads back to the broker. The broker must ensure that all payments are lawful, properly structured, and documented. Failure to do so can result in discipline under ARS, paragraph 32-2153, including fines, suspension, or revocation. This reinforces the central theme of this course. Supervision is not optional. It is the foundation of compliance. How this section connects forward. This section bridges directly into risk management and E&O exposure. Improper compensation is one of the most common triggers for audits, complaints, and lawsuits. As we move into the next sections, we will continue to build on this foundation, connecting supervision, compensation, and risk into a complete brokerage management system. The takeaway is clear: if compensation is done wrong, everything else can fall apart. Online discussion. Question 1. Why must all compensation flow through the broker? Answer: because ARS paragraph 32-2155 requires that only the employing broker may pay licensees, ensuring supervision, accountability, and proper transaction control. Question 2. What happens if someone is paid for licensed activity without being licensed? Answer: it is a violation of ARS, paragraph 32-2155, and the compensation is unlawful regardless of intent or transaction success. Question 3. Why are administrative roles a common compliance risk? Answer: because administrative staff can unintentionally cross into licensed activity, creating violations related to both unlicensed activity and improper compensation.